On March 7, 2026, in a Michigan district court, Judge Kristen Simmons presided over an eviction case between landlord Howard and tenants Monica Green and DeMonica Williams. The case, numbered 5, involved a consent judgment for unpaid rent totaling $967.64, with an additional money judgment of $790.88. The hearing took an unexpected turn when co-defendant DeMonica Williams failed to appear, raising questions about proper notice and whether a default judgment should enter against her, particularly after evidence emerged that she may have moved out months earlier and notified housing authorities.
Scheduled for a hearing before Judge Karen. I have a consent judgment. You can remain standing. It says here that the judgment will enter to retain $783 plus other money due. Is that $70? Is that what that says?
40, and I had Judge Buchanan does it that way.
Does what? What way?
She separates the late fee. That's a $40 late fee.
Okay, it's $40 for late fee. Okay, and then a court cost of $144.64, correct?
Yes.
Okay, for a total amount due $967.64. And that you'll pay that or you'll vacate by March 9, 2026, correct?
Yes.
It also has a money judgment that you're consenting to, $646.24 plus $144.64 for a grand total, $790.88. You understand that you have the right in this matter to proceed to a trial?
Yes.
You want to waive that right?
Yes.
You have the right also to be represented by an attorney. You want to waive that as well?
Yes.
Anyone threatening you to do that?
Your Honor, I see we don't have we have a default from Monica Williams. I don't know if that can go on the same form or if that needs to be a separate.
It definitely can't go on this one because if the clerk's office get 2 checks, how do they know what's correct? So it's a separate form for the defaults.
Okay.
I will cross to Monica out. She's not here.
No, she don't stay with me. She stay in Saginaw, and plus she's in the hospital. My daughter's sick. She's in the hospital.
She's on the lease.
No, she shouldn't be, because when I filled it out for DHS, I don't know if I'm sorry, not DHS, but
She's on the lease.
with Section 8, I mean, they should have took her off because I let them know that she's not.
Monica Green entered into a consent judgment for $967.64 in unpaid rent and court costs, waiving her right to trial and to an attorney. When the landlord sought a default judgment against co-defendant DeMonica Williams, Judge Simmons discovered Williams had allegedly moved out 5 months prior and may have notified Section 8 housing authorities, prompting the judge to remove Williams from the judgment entirely. Under Michigan Court Rule 2.603, a default judgment may enter against a party who fails to appear or respond to a complaint, but the court must ensure that service of process was proper and that the defendant had actual or constructive notice of the proceedings. The rule requires plaintiffs to demonstrate compliance with MCR 2.105, which governs service of summons and complaint, including personal service, substituted service, or service by certified mail with return receipt requested. Additionally, under Michigan Summary Proceedings Act, MCL 600.5744, landlords must prove they have a valid landlord-tenant relationship with each defendant named in the eviction action, and courts have discretion to sever claims against defendants, where the evidence suggests no such relationship exists. Judge Simmons applied these protections when she questioned whether DeMonica Williams had been properly served and whether she remained a tenant at all. When Monica Green testified that Williams had moved to Saginaw 5 months earlier, and that Green herself had notified Section 8 of Williams's departure, the judge faced a factual dispute about whether Williams still had any legal obligation under the lease, rather than risk entering a default against someone who may no longer be a tenant and who was hospitalized and unable to defend herself. The judge exercised her discretion under MCR 2.603 to withhold the default and removed Williams from the consent judgment entirely. This judicial caution protects defendants from default judgments entered without adequate notice or against parties who may no longer be liable, preserving the fundamental due process principle that courts should not render binding decisions affecting individuals' property and credit interests without ensuring they had meaningful opportunity to be heard. The episode also illustrates how public housing programs like Section 8 create parallel notification requirements that can affect landlord-tenant litigation, and why judges must investigate rather than rubber-stamp default requests.
So you received Section 8?
Yes.
Section 8 was advised she's not there?
Yes.
And so then you were advised she was not there?
I don't know. I was
You
not
receiving
advised. I don't know that Monica Williams is not in the house.
Yeah, that's how Section 8 works. If Section 8 got a new lease and it doesn't include DeMonica, you were aware of that.
I don't think so, no.
But I'm sorry, but it's still.
It's not about being paid. It's about getting the default, which goes on your daughter's credit.
Oh, okay. So,
What lease are you pulling up? The original lease?
This is the original
Well, it's been
lease.
changed since then. You have, what
No.
Section 8 has?
no, I don't. I just had what, as far as, I'm sorry, the court papers that was sent.
Oh,
sent to
okay.
me.
Okay, but you said that Section 8 pays your portion of the rent?
Yes,
How long has DeMonica been living in another, well, you said she lives where?
she's in Saginaw.
How long has she been living in Saginaw?
She been gone for like 4-5 months now.
Okay, and
She's
when did you all notify Section 8 and Mr. Dowith of this?
I notified Section 8 about a month after she moved out and let her because she said she wasn't coming back.
Okay, and she's originally on your lease?
Yeah.
She originally signed the lease. You recognize that? She has a new lease?
Excuse me?
She has a new lease in Saginaw?
She stayed with my sister.
Okay, you're seeking money judgment against DeMonica?
I'm not overly worried about DeMonica. With a money judgment, I think Ms. Green is gonna come up with this money.
Just gonna say, I don't know if we had service, how the service was for her. I don't feel comfortable granting a default for DeMonica if she told Section 8. I don't have proof of that right now. I've crossed DeMonica off this. So judgment's only entering as it relates to this paperwork for her.
Okay.
Again, you have 3 business days to return to the court or have to set aside if you later realize you misunderstood your rights that you waived. Do you understand that?
Yes.
Do you have any questions?
No, ma'am.
It's March 7th, is that? I think it says the night. Your copy of the paperwork in just a moment. Is this ours? You can have a seat. We'll get you your paperwork.
The landlord's attorney admitted uncertainty about how DeMonica Williams was served with the lawsuit and acknowledged discomfort with obtaining a default judgment against her, given the evidence that she had moved out and notified Section 8. Judge Simmons then formally removed Williams from the judgment, limiting it to Monica Green alone. Michigan Court Rule 2.105b requires that service of process be made by delivering a copy of the summons and complaint to the defendant personally, or by leaving copies at the defendant's dwelling with a person of suitable age and discretion, or by mailing to the defendant's last known address by certified mail, with return receipt requested. In the 2019 case of Titan Inns Co. v. Heighton, the Michigan Court of Appeals emphasized that strict compliance with service requirements is essential because it triggers the court's jurisdiction over the defendant. Defective service renders any subsequent judgment voidable. Furthermore, under MCL 600.5744 of 2, in summary proceedings for possession, a landlord must prove that each defendant has a current tenancy interest in the premises, and courts may dismiss claims against defendants who have properly terminated their tenancy or been removed from lease obligations through housing authority processes. Here, the landlord's attorney could not confirm compliance with MCR 2.105's service requirements for Williams, and the evidence suggested Williams may have effectively terminated her tenancy through Section 8's lease amendment process. Judge Simmons's refusal to enter a default against Williams aligns with Heighton's jurisdictional concerns and the statutory requirement that landlords prove an ongoing tenancy relationship. By crossing Williams off the judgment, the court ensured that any future enforcement action would not improperly affect Williams's credit or rental history based on potentially defective notice or a lapsed tenancy. Defaults carry severe consequences, damaging credit scores, creating public records of eviction, and potentially affecting future housing eligibility, making judicial scrutiny of service and tenancy status essential safeguards against erroneous judgments. This case demonstrates that even in seemingly routine eviction matters, judges must act as gatekeepers to prevent defaults against defendants who may have valid defenses or who were never properly brought before the court, protecting the integrity of the judicial process and individual rights. Judge Simmons accepted Monica Green's consent to judgment for 967 balloons and 64 zics in unpaid rent and costs, with payment due by March 9, 2026, or vacating the premises. Green waived her rights to trial and counsel. The judge removed co-defendant DeMonica Williams from the judgment entirely, declining to enter a default against her due to unresolved questions about proper service and whether Williams remained a tenant. Green was advised of her 3-day right to set aside the judgment if she later realized she misunderstood her rights. This eviction hearing illuminates a critical tension in landlord-tenant law: the efficiency of summary proceedings versus the due process protections that prevent wrongful displacement and credit damage. Michigan's eviction process moves quickly. Tenants often have mere days to respond, but courts retain affirmative obligations to verify jurisdiction, proper service, and the existence of a cognizable landlord-tenant relationship before entering enforceable judgments. Judge Simmons's refusal to rubber stamp a default against DeMonica Williams, despite the landlord's initial request, exemplifies how trial courts serve as constitutional backstops, even in high-volume dockets. The episode also reveals the complexity introduced by public housing subsidies like Section 8, where lease amendments and housing authority notifications can alter tenancy relationships in ways that private landlords may not immediately track. For viewers, the takeaway is that procedural protections in eviction cases are not mere technicalities. They are substantive safeguards against erroneous judgments that can haunt defendants for years through credit reports and housing barriers. Whether appearing pro se or with counsel, tenants should understand that judges have discretion to investigate defaults and sever claims, and that evidence of changed circumstances like a co-tenant's departure and housing authority notification can defeat liability even after a lawsuit has been filed. If you or someone you know is facing eviction, remember that consenting to judgment waives significant rights and that defaults carry lasting consequences. Contact your local legal aid society or tenant rights organization to understand your options before any court appearance, and always verify whether all named defendants were properly served and remain legally liable under your lease.